reliable source for live meetings. The Government Channel presents
Welcome to Straightforward Conversation. I'm Gary Hunter. My guests today are Athens County Court of Common Pleas judges L. Allen Goldsberry and Michael Ward. Judge Goldsberry is an Athens County native graduating from Ohio University summa cum laude with a bachelor's degree and has a Juris Doctorate degree from Duke University. He's been a judge of the Court of Common Pleas of Athens County since 1987. Judge Ward is a 1971 graduate of the Ohio State University College of Law, and he was elected Athens County Prosecuting Attorney in 1980 and served in that capacity until 1992 when he became a judge of the Court of Common Pleas of Athens County. Good evening, gentlemen.
Good evening, Gary.
Today's topic is going to be the Common Pleas court system in Athens County. Judge Goldsberry, I'd like to start the discussion off with a question directed towards you. And my notes tell me here that you're the more senior of the two members of the court, meaning that not in age, but in terms of being in office. So I'm going to ask you to describe the jurisdiction of the Athens County Court of Common Pleas, and why do we have two Common Pleas judges?
Well, that's two questions. Let's take the first one.
Attorneys are good at that.
The jurisdiction is very broad. People usually think of the Common Pleas Court as the court where felonies are tried. And it is true we have criminal jurisdiction, and the criminal cases that we try are felony cases. But we also have domestic relations, which covers divorce, dissolution, paternity proceedings, annulment proceedings, modification hearings, and things of that sort. We have limited appellate jurisdiction to hear appeals from administrative bodies like the Board of Zoning Appeals, workers' compensation cases, Civil Service Commission cases. And we also have a number of other extraordinary cases like mandamus actions, habeas corpus proceedings on occasion, appropriation proceedings, and the usual range of civil cases like contracts, automobile accidents, professional malpractice, things of that sort. I think that gives you a general idea of what we do.
I know you don't hear all, as on a routine basis, all civil or all criminal cases. There's another court system in Athens known as the Athens County Municipal Court. Just for our audience's edification, where does the distinction lie as far in criminal cases first and then civil cases?
Well, Judge Bennett is our municipal court judge, and he handles all misdemeanors, which involve cases where the punishment does not routinely involve imprisonment, but only county jail time. But he does hear preliminary hearings in felony cases where he decides whether or not there's sufficient evidence to bind an individual over to the grand jury. Then once that's accomplished and the case goes to the grand jury, then it's Judge Ward's responsibility and my responsibility.
And in civil cases, I believe it's primarily a dollar jurisdictional basis difference.
Monetary jurisdiction, although there are some areas where I think we have concurrent monetary jurisdiction. And I think the statute may have just changed. It was $10,000, maybe up to 15 now.
I believe it's 15 now, yes. Judge Ward, of interest to our listeners may be receiving in the mail that little notice that says they're to be served on, they have to serve on a jury. Could you describe how they're selected to serve on a jury in Athens County? First, to become part of a jury panel, and then to actually become seated on a jury.
Sure. The eligibility, if you have a driver's license, if you register to vote, we use both of those pools as prospective jurors. And every December, the jury commissioners, there'll be two jury commissioners and get together in our courtroom and draw the jury for the next year. And this is happening, I think, the first week of this December of this year, and for 1997. We'll draw all the petit jurors, which means all the jurors that serve on the civil or the criminal cases, 12 people for criminal cases, 8 people in your civil cases, and make a finding of guilty or not guilty in criminal cases, or liability or not liability in civil cases. Each juror will serve for 30 months, or excuse me, 30 days. That's once a month. 30 months would be quite a long time, but for 30 days, and we each have a panel on that for the petit jury. Now, with regard to
Are they the same panel or are they different?
there'll be different panels. Judge Goldsberry has a panel, I have a panel, and then on grand jury, there's only one panel, and each grand juror serves for a 4-month period, and the grand jury meets once a month, so a grand juror would probably serve twice during that 4-month period.
You mentioned something interesting to me, and I wanted to follow up on it, that to be eligible to serve on a jury in Athens County, your pool is taken from people who have a driver's license or a register to vote. I was quite familiar with the register to vote. The driver's license is kind of a new concept to me. That raises the issue. Driver's licenses are issued at the age of 16 here in Ohio. Is 16 now an age in which you can serve on a jury in Ohio, or do you have to be 18?
You have to be 18.
So you sort out those 16-year-olds on a driver's license basis?
Actually, we get a list generated by the Bureau of Motor Vehicles, and we get a list generated by the Secretary of State. The Secretary of State voters, the Bureau of Motor Vehicles automobile licenses. And those lists are integrated, and we get computerized lists which we put together to come up with a panel. Now, once in a while, you get somebody's name that's on both lists. But you can't serve twice in the same case, obviously, unless you have a double or something, I suppose. But there's very little problem with double names. We do seem to have a problem now and then with people get called more often than you would think when you consider how randomized the list is.
For example, what we'll do is we'll tell the Secretary of State this year, send us every 13th name on your list. In 1997, we may say, send us every 15th name. That's so we don't get to hit the same people every time. But as Judge Goldsberry has indicated, some people get called a lot, some people never get called. It's something we try to eliminate if we can do that, or reduce that from happening, but there's still some that slip through the cracks.
For a civil trial first, how many jurors would be called in a pool to try to seat a jury, and are we seating 12 these days for a civil trial?
No, we're seating 8 in a civil trial, and again, this depends upon the number of parties. If you just have a plaintiff and a defendant, each of those gets 3 peremptories, which means that you can excuse a prospective juror for no reason at all. And in that particular case, we'll probably call in about 25, 26 people. Now, in a criminal case, where you have to seat 12 members of the jury, usually have, depending upon the length of the trial, 1 or 2 alternates. There's 4 peremptories for each side, plus 1 peremptory for the alternate spot. So we may call in 30, 35 people in a case like that, just so we have enough jurors there in the courtroom and don't have to go out on the streets and look for jurors, or postpone or delay the trial until we get enough jurors.
Which raises another interesting issue. A lot of people don't particularly want to serve on a jury due to time constraints or insufficient financial compensation versus their job to be there. How lenient are you to allowing people to remove their names from a jury list for those kinds of reasons? I simply don't want to serve because of financial compensation, or I don't have the time to do it.
I think our policies are similar, although we probably don't enforce them exactly the same. But speaking for myself, I would say I'm not very lenient. The most common complaints I receive, not all of them by any means, but the most common complaints are from Ohio University students. Now, we've had a lot of students serve on jurors over the years, as jurors over the years, and they do a great job. But they oftentimes don't realize that it's one of their responsibilities when they register to vote here. So as soon as they get called for a jury, it's not unusual for, if the student doesn't contact the court, the parents will and say, look, our daughter's down at Ohio University going to classes. They don't have time to go to serve on juries, and usually we don't accept that excuse. You get a lot of arguments. We'll point out that many times it's an inconvenience for a small business owner to have to come in. Maybe he or she doesn't have someone that can take over the business while they're down at the courthouse, but we still make them come in. We try to minimize the inconvenience by saying to them, well, first of all, you're only on call for 30 days, and you may not have any trials to come in on at all. And second of all, our trials usually don't last more than 2 or 3 days at the most. They aren't 6-month trials.
Is there any right to a racially balanced jury?
A right to a racially balanced jury. Let me kind of turn that around a little bit and answer it this way. If it appears that an attorney is trying to excuse a juror because of race, that excuse or that peremptory challenge can be challenged by the opposing side. And the Supreme Court says that there has to be a kind of a dialogue with the court and counsel for the counsel making the excuse to articulate reasons other than race why that attorney wants to get rid of that prospective juror.
Interesting. Stay tuned. Judges Ward and Goldsberry and I will return after this commercial break. When we do, I want to ask them about courthouse security and whether it's really necessary in Athens County. Welcome back to Straightforward Conversation. My guests this evening are Judges L. Allen Goldsberry and Judge Michael Ward of the Athens County Court of Common Pleas. Welcome back to Straightforward Conversation. My guests this evening are Judges Allen Goldsberry of the Athens County Court of Common Pleas and Judge Michael Ward of the Athens County Court of Common Pleas. Judge Ward, before the break, I was about to ask you about courtroom security. It seems to be the hot topic sweeping across the country right now. Is it really a problem in Athens County, and do we have any kind of security problem that is being addressed?
There have been some instances in the past, fortunately minor, that have come to our attention and we want to avoid in the future. The Supreme Court last July came out with a directive that each county come in with court security plan. And that has been implemented, and we've done some things here in our local courthouse. The commissioners have hired a constable force to provide security for the courthouse. That's the 4th floor of the courthouse as well as in the annex. We have panic buttons in our courtrooms as well as desks for the staff, and there's also signs that have been posted that you're subject to an administrative search if there's suspicion that you carry weapons into the courthouse. So other plans out there, Franklin County and bigger municipalities have implemented metal detectors. That's been done within the last recently in Franklin County. And some other plans and programs are out there. There's suggestions of cameras and different things like that. But so it is a more right now. Fortunately, nothing's going on in Athens County, but I think it's a preventive type of step.
Judge Goldsberry, it seems like Athens County is kind of taking a middle-of-the-road kind of stance. I know some of our adjoining counties have, Zanesville, and the one that comes to my mind, has put up the metal detector before you enter the courtroom. I personally, as an attorney and entering the court system, find those to be kind of objectionable. It kind of makes people feel like it's a military state kind of situation and chills people's feeling about coming into court and watching the proceedings. How do you feel about that?
Well, I guess the way I would answer that is to say what I feel really is irrelevant, because the Chief Justice has told us that we're going to have a superintendent's rule that we must live with. So far, the actual procedures that you take are not mandatory. It's being studied. In other words, Judge Ward just mentioned we have a constable, and one of his responsibilities is to log any instance that we have that might be deemed security problems, and then the Supreme Court collects these each year from each jurisdiction and will presumably decide whether the Chief Justice will tell each court what you must have. But I would say that there has been some reaction, adverse reaction, to the kinds of security devices you've mentioned. The most recent that I'm aware of is in Franklin County. Apparently the Domestic Relations Court in Franklin County has had these measures for a long time. But the general division next door has not. And obviously it's a nuisance if you're hurrying to get to court and you've got to stop, take your briefcase out, run it through a machine, walk through yourself, and if you have a pocket knife or a pen or something that sets the buzzer off, you have to stop and be searched. And it's also a bit demeaning to some people. And in Franklin County, a lot of people don't like it. But I've also heard a lot of people say, well, we accept this in airports. Why shouldn't we in the courthouse, where people are coming in to litigate matters and they're not really happy with one another when they're in there? So maybe it's a precaution that we should accept.
Maybe one might think it's strange, but the domestic relations area is the area of most concern, where the emotions are highest. And so great attention is paid up there by our constable. In the past, getting back to metal detectors, there have been a couple cases of murder cases in the past. The county has rented metal detectors and required people entering the courtroom to pass through those metal detectors.
Do either one of you feel that security, there's a need for higher levels of security now than there was, say, 5 or 10 years ago?
It's my belief that they will be mandated. I know of another county in southeastern Ohio, near us, where one of the judges is wrestling with the problem about what happens if he does not install devices that are designed to detect weapons. Is he building in a lawsuit for that particular county because he doesn't have that equipment? So I think it's going to be mandated eventually. But in the setup that we have here in Athens, as you're aware, Gary, we have the courthouse and then we have the administrative annex. I think those precautions and those methods will be limited just to the courthouse side.
I think most people in Athens County would be familiar with the fact that there's one common pleas judge, and of course now in Athens for at least close to 8 or 9 years now we've had 2. Mike, could you address how we came about to get a second common pleas judge in Athens?
Well, every county in the state, there's 88 counties, and each county has at least one common pleas judge by statute. And our second seat, which I hold, and my predecessor was Homer Gall, Judge Gall, that was created by the General Assembly. After going to the General Assembly, Judge Goldsberry went there along with other folks from our county and the Bar Association, presented statistics and made an argument for this seat. And the General Assembly was persuaded and passed legislation creating this seat. And Judge Gall took office in the summer of '91.
So it's not just a factor of population or caseload that is a deciding factor in that?
It's in part whether the local county commissioners believe there's a need in order to provide adequate services to the county. If the Bar Association thinks that they could get more done, get more cases tried or resolved. Now, I wouldn't say that that doesn't mean we won't tinker with the system. Some counties are finding that that cases that used to be in domestic relations are now in the juvenile court, and that's what's prompted the family law court movement that you may have heard about.
Are cases being tried faster in Athens County now as a result of 2 judges? I used to be, we would think, 2-3 years for a civil case to come to trial. Do they come to trial faster now?
Oh, definitely. Very definitely. If you want a trial in Athens County and you want it in a personal injury case or any other kind of case, but let's use a personal injury case in less than a year and less than 9 months, you can get it. And criminal cases could be tried even faster if the parties wanted them tried faster. Sometimes it takes time for various things to develop, but cases are being tried much faster.
Of course, a lot depends upon the complexity of the case and the attorneys getting the case prepared for trial. That takes 6 to 9 to 12 months sometimes, depending upon the type of case.
Well, stay tuned. Judges Ward and Goldsberry and I'll return after this commercial break. When we do, I want to talk about recent trends in sentencing. Welcome back to Straightforward Conversation. My guests this evening are Judges Ward and Goldsberry of the Court of Common Pleas of Athens County. Judge Ward, I would like you to address the issue of sentencing in criminal cases and the recent trends that we're seeing across both the state of Ohio and Athens County.
With regard to recent legislation, what's called Senate Bill 2 is a major piece of legislation that went into effect. And it basically was a sentencing bill. We restructured the sentencing, and it had several purposes. One purpose was truth in sentencing. And before the Senate Bill 2 went into effect, those people who were sentenced to prison, for example, 15 years, got good time, which is usually a third of their sentence, so that they were eligible for parole, let's say, after 10 years. Now, if a person is sentenced for 10 years, they stay in prison for 10 years. So the purpose is to have the violent offenders go to prison, whereas those on the lower end go into what's called community control sanctions, and that phrase replaces the phrase of probation that you've heard. The number of felonies was reduced from like 12 to felonies 1 through 5, 1 being the more serious, such as your rapes, aggravated burglaries, aggravated robberies, down to your 5th degrees, which would be the lower end, such as thefts. There's a presumption that those convicted of the 1st and 2nd degree go to prison. There's also a presumption that on the lower end, the 4th and 5th degrees, go into the community sanctions. And community sanctions are residential and non-residential. The two residentials, one is the SEPTA Center, the Southeastern Probation and Treatment Alternative Correctional Facility up in Nelsonville, Ohio, which is a 6-month program. 60 days is confined, where a person undergoes counseling, treatments, gets acclimated, and then the remaining 4 months, the person gets out and gets a job, community service, and does other things. Still has the counseling and things like that, but at least gets out in the community, the steps towards rehabilitation. The other residential sanction is the jail, and the multi-county jail that's going to be up in Nelsonville, and that's a multi-county facility with Perry, Hocking, Morgan, and Athens counties, will initially house 144 prisoners. Non-residential treatment facilities or modes are restitution. Although we don't have day reporting yet, we've applied in the past for a grant for day reporting systems, the leg monitor situation, and counseling, job counseling, as well as alcohol drug abuse counseling, and fines, things along that line.
You said there are presumptions depending on the level of felony that you're convicted of, whether your term of jail or other forms of incarceration are available. Are those mandatory upon the judges, or do you still have a fair degree of discretion as to what a sentence is going to be?
There's a presumption that those convicted of 1st and 2nd degree felonies go to prison. Now, if the court doesn't send someone to prison, then the court has to state on the record why there's a deviation in that sentence. And if there is a deviation and you don't send somebody to prison, then the prosecuting attorney can appeal that. Now, by the same token, the presumption that 4th and 5th degree felons go into community control sanctions, if the court has to state on the record why there's a deviation if they're sent to prison, and then the defense attorney can appeal. And even though there is that presumption of the 4th and 5th degree felons getting community control sanctions, there's like 8 exceptions to that. If the court finds, for example, that there was harm involved, or it was a sex offense, or someone has been in prison before, or violated community controls, that would be a grounds not to follow the presumption.
Well, it certainly sounds like the new sentencing law is going to go a long way in restoring public confidence in sentencing of felons across the state of Ohio.
It's the first time in our history that we have appeals of judges' sentences.
Very good. It's been a very interesting conversation. This has been Straightforward Conversation. My guests this evening have been Judge L. Allen Goldsberry and Judge Michael Ward of the Court of Common Pleas of Athens County. Good evening.